In a previous show, we discussed several pitfalls with signing assisted living or nursing home contracts. This week, we address a huge issue that will affect families with grievances against nursing homes, the mandatory arbitration clause. The laws have changed recently, and my law partner, Mike Solomon, is here to discuss the changes.
Hey,
so first, what's an arbitration clause in such a contract, and how is it a problem for the family?
Well, an arbitration clause in a contract, what happens if you have an accident, you're disputing what's happening at the long-term care facility. If you have an arbitration clause, you have to go before an arbitrator. If you don't have that, you get to go before a judge and a jury, and judges and juries tend to be a little bit more friendly to people who have been injured, and arbitrators tend to be more friendly to the long-term care facility.
Okay, so how have the clauses been treated in the past?
Well, in the past, what's happened, before they made this recent change, excuse me, is that they put the arbitration clause in the contract, but you could opt out of it. So, most people would opt out, and then they could use the court system if they needed, where if they left it in, then they'd have to go to arbitration.
So what happened recently in the law?
Well, the American Bar Association back in 2015 came out with a recommendation that they get rid of these arbitration clauses completely, don't allow them in the contract. And then CMS, the Center for Medicare and Medicaid, passed a regulation that basically said you can't put those in there anymore, and that would become effective sometime in 2016.
So what happened?
Excuse me. What happened was that the American Healthcare Association, excuse me, they went to court right before the regulation was supposed to become effective. They got the court to declare that it was invalid. Basically, the court said it may make sense to have a prohibition against arbitration, but that's Congress's job, not a government agency. So that was put on hold.
Okay, so that doesn't sound very good. Any more to this saga?
Yeah, well, what happened eventually is that then with the new administration, they came out with new regulations and they flipped it. They went ahead and said that not only can they have that arbitration clause in the contract, they can mandate that you can't get into the facility unless you agree to arbitration. And that became, the comment period ended a few months ago, and now we'll have to see if they finalize. But if they finalize it, they'll be able to put it in your contract. You won't be able to refuse it. You'll have to take it to get in the facility.
And that sounds not so good for folks these days. Right. In addition to the other pitfalls in nursing home admission agreements, now families' rights to legal recourse against the facility may very well be limited to arbitration under this new ruling. Please be sure to read any agreement before you sign it and seek the assistance of an elder law attorney to uphold your rights. Please contact Mike for more information. The number's next.
Call Solomon, Steiner, and Peck at 1-888-236-5173 for more information or to schedule a speaker for your organization. Or log on to www.ssnplaw.com.
Thanks for joining us. On next week's show, 'tis the season to stay healthy. We'll unwrap reminders to keep you feeling fine. Then, is it time to let nature take its course? We'll determine if a dam needs to be torn down. And volunteers are vital to keep organizations operating well. We'll salute these unpaid yet priceless people. But until then, please remember to make the most of your golden opportunities.
If you'd like to join our kitchen conversation, visit our website, www.goldenopportunities.tv. Like us on Facebook. Call us at 440-742-GO-TV or email us at kitchen@goldenopportunities.tv. We'd love to hear from you.
Golden Opportunities is paid for by Elder Productions.